1786, 1790, when the Bill of Rights was incorporated in the United States Constitution. And certainly looking at all these foreign countries of which we don't know much and which are anyway different and definitely inferior to the United States of America. And he criticised his colleagues very, very aggressively. And since then, there's been a real decline, if not a disappearance, of reference to these things, because it's just not worth it. Now, I am made of more robust stuff, and the criticisms which were expressed in Al-Kateb against Godwin, which was a case in the High Court of Australia where I had referred to international jurisprudence in a constitutional context, merely encouraged me, because the fact that others were joining issue and disputing it, I thought was a good thing, because that at least allowed the issue to be on the table and debated. But not everybody takes that view. Some people prefer a quiet life, and they don't want to get into battles of that kind. But you're quite right. I think there is a question of attitude, and the attitude is, do you think international law has anything to say to the municipal legal system, or do you think this is a foreign system and you don't have to pay much regard to it unless it is specifically incorporated? Now, in the case of the Child Abduction Convention, exceptionally, this is a case where, although not expressly incorporating the Child Abduction Convention, a technique was used in the Family Law Act of providing that regulations might be made to give effect to the convention, and then the regulations were drafted in parallel terms to the convention, so that in effect, though not in the normal way, the convention was incorporated into Australian domestic law. So this is a case where not only can you refer to international law and the International Convention and what it says, but you have to do so, because effectively it has been incorporated. And therefore, it's appropriate to look not only at what you are doing, but what other countries are doing. Yes?
Thanks, Justice Kirby, for coming and speaking to us.
Speak up.
My name is Peter, so thank you for coming and speaking to us firstly. A couple of observations.
Did you bring in the camera?
No. No.
Who brought in the camera?
He's an absentee at the moment.
He was late and then he left.
Oh no, the man just turned up and set it up and then left the room.
Yes, but he was late. He missed the best bits.
Just as well we've got it all being filmed, because he
I
can
might
hear
have to
the
go and do
disdain.
a cameo introduction all again. Anyway, we won't do that now. You speak up and say what you want to say.
There's a couple of observations that sit uncomfortably with me in relation to the judgments through the lens of individual...
You have to speak up, especially if you're going to become a lawyer and an advocate. I can't hear you.
Through the lens of individualised justice.
Yes.
The cases, if anything, seem to me to be punitive, in the sense that they're punishing the abductor and they're coercive in the outcome for the, arguably, the innocent party, in the name of sort of a wider social good of reciprocity and a public interest in having Australian nationals returned to abroad. So in the sense of an individualised justice, it's something of a leap of faith for me.
The individualised case is an instance of the application of the general provisions. And the general provisions can't be understood unless you understand what they're getting at. To understand what they're getting at, you have to study the language, but you also have to study the history of how the International Child Abduction Convention arose, what was the mischief, as we like to say in the law, a very mischievous word, what was the social defect that the International Child Abduction Convention was trying to deal with. Now let's just ask ourselves what that is. What it's trying to deal with is aeroplanes. In the old days, okay, somebody could get on a boat in Genoa and come out here very, very slowly through the Suez Canal unless it was blocked, and then come down to Australia, and after 3 weeks they could be in Australia. But now you hop on a plane and you're here in a day. And this is now a worldwide phenomenon. Children can be grabbed, taken, and be on the other side of the world. And the practicality, just imagine if that happened to a child. The practicalities, you suddenly, you know, where are they? Where are they? Why aren't they home? Why aren't they home from school? In the case of Justice Forrest had, there were 4 daughters, and the parents had appeared before the family court in Italy, and they had agreed on joint custody and residence in Italy, and the husband, the father, agreed to a 1-month holiday so that the wife, who was Australian, could take the children out to Australia. And then suddenly they don't come back, and all the dresses are laid out and the books are there and the school is organised, and they're not there. I mean, it's a terrible affront. It's not quite as bad as little Megumi going home from badminton practice and suddenly disappearing and no one knowing she'd been murdered or what's happened. Apparently she was abducted, so the best one can tell, because North Korea is a very secretive place, in order to teach modern Japanese idiom to people in North Korea, particularly people in spy school, so that they would have the latest ways of speaking Japanese, so that they could assume the personality of people who were abducted as adults and be able to speak Japanese in a contemporary fashion. That's the best explanation anybody has of what happened to Megumi. Megumi, later, it was revealed that she had been abducted, and one of the few concessions that Kim Jong-il, father of Kim Jong-un, the disappeared one, one of the cases where he accepted that they had done wrong was grabbing Megumi, and she died in custody in Japan, or under detention, and it was subsequently said that she had been killed in a motor crash. That was what they said happened to a lot of the people. It must be a very dangerous place up there, even though their roads are virtually empty. And bones that were sent back to still the loss of the parents were found to be dog's bones, the DNA research. So it's a very curious case, but extremely upsetting. To suddenly change human interaction by the disappearance of somebody is a very confronting and wrong thing to do. And so what you've got to do is look at what it's trying to do, and it's not illegitimate to do that. Even very orthodox lawyers will do that, looking at what the mischief is that the convention is trying to operate. And it's not a matter of doing great social engineering, it's a matter of giving effect to what the convention says. Yes?
Do you think that it's particularly difficult in common law jurisdictions outside of nationalism to sort of give effect to these kinds of conventions?
Why should it be difficult in common law jurisdictions?
Well, there's something, there's a sort of theme or allusion that is not explicit in some of the judgments, that there's some kind of procedural or further for factual disputes and things like that in the common law system is not necessarily.
That's actually quite an interesting question. I hadn't thought of that. Certainly, common law jurisdictions have certain features about their dispute resolution methodology. Those features include having officials called judges who in the common law system have a higher status and importance than the magistrat and other judicial officers in the civil law tradition. That probably arose, again, historically from the fact that the English tended to appoint their judges, who were few in number, from the bar, and therefore they were never sort of just public servants. They were people who were accomplished professionals who spent a bit of their life working in the public purse and had a high status. Judges on the whole in the common law have a higher status in the system of government than the judges in the civil law tradition. The common law is about a third of the world, the civil law is about 2/3 of the world. Therefore, there are more of the civil law systems than there are of us. And it may actually be that it is that status, feeling of importance, actuality of importance, that makes judges in common law countries more scrupulous and careful in their fact-finding, more public in their performance of their fact-finding, and therefore more inclined to go into the law and justice of a problem before them and not to regard themselves as lower type officials who are just part of the machinery of government. You follow?